Now, the Defense Department's General Counsel discusses the administration's opposition to part of the defense programs bill having to do with the detention of terror suspects. The administration says that the provisions would limit the president's flexibility in dealing with terrorists. From the Heritage Foundation, this is An Hour.
Good afternoon. Thank you for joining us here at the Heritage Foundation. As Director of those who join us on our heritage.org website on all of these occasions, would ask everyone here in-house if you will be so kind as to check cell phones one last time to see that they are turned off as we proceed with the program. My staff, and I know the camera crew at the back, will be especially happy for you to do that. We will post the program within 24 hours on our website for everyone's future reference, and of course, email comments and questions can be sent to us at any time, simply emailing speaker@heritage.org, speaker@heritage.org. Introducing our special guest this afternoon is Cully Stimson. Mr. Stimson serves as Senior Legal Fellow in our Center for Legal and Judicial Studies. He is a leading expert in criminal law, military commissions, and detention policy. Before joining us, he served as Deputy Assistant Secretary of Defense for Detainee Affairs, where he advised the Secretary of Defense on detainee issues worldwide, including Guantanamo Bay, Iraq, and Afghanistan. He also served 4 years as an Assistant U.S. Attorney for the District of Columbia. Before that, he was a homicide prosecutor in Maryland and a domestic violence prosecutor in San Diego. Please join me in welcoming my colleague, Cully Stimson. Cully?
Thank you, John. We are delighted, and I'm personally delighted, to welcome Jay Johnson here to the Heritage Foundation today. After President Obama was elected, but before he swore an oath to the Constitution, a senior high-ranking military official called me, and I'm a military officer in the reserves. And I knew this person, I know this person, and he said, you really ought to have a chat and get to know Jay Johnson, because I know him. He served with distinction as the Air Force General Counsel during the Clinton administration, and you two should get to know each other. And so I cold called him. He was running transition and point at the Pentagon, and he took my call. And that began a professional and collegial conversation, and I would say friendship, that started December, January, before the president took office. I told him during our first call that I supported military commissions in general, but that I opposed the 2006 Act. And then I sent a memo to the Secretary expressing why I opposed the Act, and I also told him I thought that those fixes were doable, and I hoped that the administration would upgrade and keep the Military Commissions Act, and indeed they did that. We've had numerous conversations, or several conversations, I shouldn't overplay it, since then, and I have found those conversations to be constructive. My point is this, that for too long, and certainly there are marked examples in the last 10 years, there's been an over-politicization of detention policy and matters. And we've come to a point now, 10 years since 9/11, where there's been, fortunately, a odd but favorable convergence of opinion on the broad questions. An acceptance in the main for military commissions, an acceptance in the main that we're at war, an acceptance that pursuant to war, military detention is a necessary aspect of the war effort. The topic today is more detainee legislation necessary? We ask that because, as you all know, there are two competing bills, one in the House and one in the Senate, that contain various provisions dealing with detention. But it's important to put this into context. Since 9/11, the United States has detained well over 100,000 individuals. Some are repeat customers, they're recidivists. Most were detained in Iraq. Over roughly 20,000 or so were detained in Afghanistan. And at its peak, Guantanamo had 778 individuals, and now we have 171. The principles involved the important principles are not the numbers, but the underlying respect for the rule of law and the national security of our country and our allies. And so the legislation today doesn't address the big issues, the big boulders that have bounced around since 9/11, but are refinements to existing policy or attempted refinements at existing policy, mainly dealing with detainees in Guantanamo. And so we're absolutely thrilled in this spirit of let's putting politics to the side and get down to the serious business of common sense legislation to have Jay here to talk about this. Jay, as I mentioned, serves as the General Counsel to the Department of Defense. That means he's the Chief Legal Officer for a whole army of lawyers in uniform and out.
Please don't say how many.
More than 10. And he's also the Chief Legal Advisor to the Secretary of Defense. He served with distinction also as a federal prosecutor in the Southern District of New York, where he took on public corruption cases. After his stint in the Southern District, he moved to the law firm of Paul Rivkin, and it has lots of other names. Paul Weiss, Rivkin, Wharton, and Garrison, where he tried high-stakes commercial corporate cases. In 1998, President Bill Clinton appointed him to be the General Counsel to the Department of the Air Force, where he served honorably for over 2 years, later returning to the law firm. He was appointed by President-elect Obama to be the General Counsel for the Department of Defense, and he's tackled a number of issues there, and I'm sure during the question and answer period, some of you may want to ask him about those things. So without further ado, I turn the podium over to the Honorable Jay Johnson.
Cully, thank you for that introduction, and thank you for the invitation to speak to this distinguished organization. Cully referred to the fact that I was a federal prosecutor for 3 years. I'm sorry that the former Attorney General could not be here today. I know of his connection with this organization. Just thinking about Attorney General Meese and the reference you made, I'm reminded of when Rudy Giuliani hired me in 1988 to be an assistant United States attorney in the Southern District of New York. I had been out of law school for 6 years, and I was a litigator, and I was anxious to try cases, and I had never tried a case. And so I got into the United States Attorney's Office and figured that I was finally unleashed to try cases. And almost immediately, I had my first trial. It was about 3 weeks into the job, and I was taught that you always give essentially the same opening statement before every jury. It varies depending on length, depending on the nature of the trial, but you essentially give the same opening statement to every jury. And it was beat into me, which is, first of all, before you even introduce yourself to the jury, my name is Jay Johnson, I represent the government, you're supposed to go over to the defendant at the defense table, and you're supposed to walk away from the lectern, walk away from the jury, and point at the defendant and say, that man right there sold drugs on the corner of 28th and 8th, and I'm going to show you how he did it. Then you return to the lectern and you say, my name is Jay Johnson, I'm an assistant United States attorney, I represent the government. And then for the next 20 minutes or so, every statement, every assertion of fact should be preceded by the evidence will show this, the evidence will show, the evidence will show. And then at the end of the opening statement, you say the same thing. In conclusion, ladies and gentlemen, I ask you to do 3 things. 1, listen to the evidence, listen to the law as Judge so-and-so instructs you, and use your common sense. And if you do those three things, I am confident you will find the defendant guilty as charged. That was the same opening I gave for all 12 of the cases I tried as an assistant United States attorney in 3 years. Some were longer, some were shorter. So now I'm out in the defense bar, and now I'm thinking this is my real opportunity to be unleashed, because I don't have to play by the same rules as the government attorneys. And it was a pro bono case. I was representing somebody accused of selling crack in Washington Heights in Manhattan. And I basically decided to use the mope defense. He's a mope. You know, he was not selling crack. He was using crack, and that's what the client told me repeatedly. Mr. Johnson, I'm not a seller. I'm just a user. And so I tried the mope defense. And I told the client, the assistant United States attorney, he's going to walk over and point at you during his opening statement. And I suggested to him what had happened to me in my first trial when I did that. I said, you know, a trial is an emotional thing, and sometimes it's okay to let your emotions go when you're accused of something really bad, whatever. And so the young AUSA, just like I did several years before, walked over, got in his face, pointed at him, and he cried right on cue. And put his head down on the desk and started bawling his eyes out. And it was great. The jury looked at him in sympathy. And then when it came time for my opening, I did not point at him. I walked over, I stood behind him, I put my hands on his shoulders, and I said, this man is a poor, penniless crack addict. And then I went into my opening statement. I did not begin every sentence with the evidence will show, the evidence will show. I gave what I thought was a pretty good opening statement, and I left the lectern, and I left my notes, and I was pretty much on autopilot, which you should not do. And when I went on autopilot, I was giving this great opening, and I said, and I'm not making this up, I said, ladies and gentlemen, in conclusion, I want you to do three things. I want you to listen to the evidence. I want you to listen to the law as Judge so-and-so instructs you. I want you to use your common sense. And if you use your common sense and you do all three of those things, you will find the defendant guilty as charged. The court reporter is sitting where Cully is, not guilty, not guilty, right. So that was my career in the criminal defense bar. Someone once told me that at some point in the history of the Department of Defense, perhaps it was my predecessor, Dan DeLorto, sitting here, the job of general counsel was a relatively sleepy one. In fact, I came to the job with the belief, based on prior experience, that an agency general counsel should rarely, if ever, be publicly seen or heard. But when I returned to the Pentagon in February 2009, after having been away for 8 years, I found a very different place. The Office of General Counsel of the Defense Department, particularly in the post-9/11 world, is in the middle of many difficult front-page issues. Guantanamo Bay, military commissions, operations in Libya, the legal contours of our counterterrorism efforts, Don't Ask, Don't Tell, WikiLeaks, Bradley Manning, the state secrets privilege. Google search my name, and you will even find a number of hits about the controversy I stirred when I sent a letter to Congress stating DOD's opposition to a bill to rename the Department of the Navy the Department of the Navy and the Marine Corps. On a regular basis now, when I read the newspaper in the morning, I discover a story or an op-ed with a public account of private legal advice I have supposedly offered in internal government deliberations. Particularly as I look around this room right now and I see all of the distinguished visitors and distinguished journalists here, I find that some people are actually interested in what the General Counsel of the Department of Defense has to say. Therefore, policy and politics aside, at every opportunity I have before civilian audiences such as this, I devote part of my remarks to paying tribute to the sacrifices and dedication of the men and women in the U.S. military. It is the case that less than 1% of the U.S. population does the fighting for all of the rest of us. These remarkable men and women in the post-9/11 military have volunteered out of a sense of public service, patriotism, and selfless duty to a larger cause. Each time I read a list of those who have paid the ultimate price, the most painful thing for me to read are the ages, 20, 21, 22, for example, not much older than my own teenage son. These young people gave their lives for their country before they ever really had a chance to know what life is all about. Many will never know the joy of marriage, of parenting a son or a daughter, and so many other experiences that a full life has to offer. Then there are those who survive their injuries and must struggle on without an arm, a leg, or something else the rest of us take for granted. Navy Lieutenant Brad Snyder is the nephew of one of my deputies. He was a member of an explosives ordnance disposal team in Afghanistan. On September 7th, Lieutenant Snyder went into a mined area to clear safe passage for a medic trying to get to others who had been wounded in action. An IED exploded in his face, severely injuring him and taking his eyesight, probably for the rest of his life. Despite his injuries and the loss of his sight, Lieutenant Snyder refused a stretcher and managed to guide the medic to those who were wounded. One of the most remarkable things about those seriously wounded in action is the powerful sense of unit cohesion and dedication they retain even after they are injured and taken out of the fight. Within hours, they will frequently express an impatient desire to rejoin their buddies in their unit and continue service. I'll never forget the amputee at Bethesda who asked me, "Mr. Johnson, do you think that this will affect my ability to get a command?" When Lieutenant Snyder learned that the Secretary of Defense was about to visit him at Bethesda, Brad said to his mother, "I need to get out of bed and stand at attention, but I have no pants." For their sacrifice on behalf of the rest of us and their dedication to our country, polls indicate that the U.S. military is the most respected and revered institution in America today. I am convinced that one of the other reasons our military is so revered and respected is that, for all its power, we place sharp limits on the military's ability to intrude into the civilian life and affairs of our democracy. This is a core American value that is part of our heritage, dating back to before the founding of our country. The Declaration of Independence listed among our grievances against the King the fact that he had kept among us in times of peace standing armies without the consent of our legislatures and had quartered large bodies of armed troops among us. This value is reflected in the Federalist Papers, and the father of our Constitution, James Madison, wrote, "A standing military force with an overgrown executive will not long be safe companions to liberty. The means of defense against foreign danger have been always the instruments of tyranny at home." This core value and this heritage is today reflected in such places as the Third Amendment, which prohibits peacetime quartering of soldiers in private homes without consent, and in the 1878 federal criminal statute, still on the books today, which prohibits willfully using the military as a posse comitatus unless expressly authorized by Congress or the Constitution. This brings me to the point of my remarks today. There is danger in over-militarizing our approach to al-Qaeda and its affiliates. There is risk in permitting and expecting the U.S. military to extend its powerful reach into traditional areas typically reserved for civilian law enforcement in this country. Against an unconventional non-state actor that does not play by the rules, operates in secret, observes no geographic limits, constantly morphs and metastasizes, and continues to look for opportunities to export terrorism to our homeland, we must use every tool at our disposal. the military should not and cannot be the only answer. Recent events remind us that broad assertions of military power can provoke controversy and invite challenge. Overreaching with military power can result in litigation in which the courts intrude further and further into our affairs and can result in national security setbacks, not gains, a point best illustrated by the question Donald Rumsfeld once asked my predecessor. So am I going to go down in history as the only Secretary of Defense to have lost a case to a terrorist? Particularly when we attempt to extend the reach of the military onto U.S. soil, the courts resist, consistent with our core values and our heritage. We have worked to make military detention, in particular, less controversial, not more. The overall goal should be to build a counterterrorism framework that is legally sustainable and credible, and that preserves every lawful tool and authority at our disposal. This has meant, as the President's counterterrorism advisor John Brennan said recently, an approach that is, quote, pragmatic, neither a wholesale overhaul nor a wholesale retention of past practices, end quote. To build that less controversial, more credible, and sustainable legal framework, we have in the last several years accomplished the following. We have applied the standards of the Army Field Manual to all interrogations conducted by the federal government in the context of armed conflict. Where appropriate, in the context of terrorist activity, we have invoked the public safety exception to the Miranda Rule created by the Supreme Court in New York v. Quarles, ensuring that the opportunity to gather valuable intelligence is fully utilized, and at the same time preserving the prosecution option. We have worked with the Congress to bring about a number of reforms reflected in the Military Commissions Act of 2009, and following that, we issued a new manual for military commissions. By law, use of statements obtained by cruel, inhuman, and degrading treatment, which was once the most controversial aspect of military commissions, is now prohibited. We have accomplished these reforms working with a bipartisan coalition in Congress and with the full support of the JAG leadership in the military. We have appointed the highly respected former Judge Advocate General of the Navy, retired Vice Admiral Bruce McDonald, to be the convening authority for military commissions, appointed a recognized military justice expert, Marine Colonel Jeff Caldwell, to be the Chief Defense Counsel for commissions, and this month appointed Brigadier General Mark Martins, a West Point valedictorian, Harvard Law School graduate, and Rhodes Scholar, to be the Chief Prosecutor. We are recruiting the A-team for this system. We have reformed the rules for press access to military commissions proceedings, established a new public website for the commission system, and in general built what I believe is a credible, sustainable, and more transparent system. In the habeas litigation brought by Guantanamo detainees, lawyers in the Department of Justice and the Department of Defense have worked hard to build credibility with the courts by conducting a thorough scrub of the evidence and the intelligence before we put forward our case for detention in the courts. We have refined existing systems for periodic review for the cases of detainees at Guantanamo and at Bagram in Afghanistan. Overall, the hard work of many civilian and military counterterrorism professionals, spanning both this administration and the last, is producing results. First and foremost, we have been aggressive and focused in the fight against al-Qaeda. Where necessary, we have not hesitated to use lawful, lethal force against al-Qaeda and its affiliates, and we are literally taking the fight to them, where they plot, where they meet, where they plan, and where they train to export terrorism to the United States. Counterterrorism experts state publicly that al-Qaeda senior leadership is today severely crippled and degraded. Second, just as we brought justice to the man who ordered the attacks on 9/11, we seek to bring to justice KSM and the other alleged planners of 9/11 in reformed military commissions. New charges have been referred in the case of the alleged Cole bomber, Hussein Mohammed al-Nashiri. Third, the government is seeing consistent success in the habeas cases brought by Guantanamo detainees. The courts have largely recognized and accepted our legal interpretation of our detention authority, and the government has now prevailed at the district court level in more than 10 consecutive habeas cases brought by Guantanamo detainees. We are seeing a similar good result in the D.C. Circuit. In the D.C. Circuit also, the Department of Justice successfully defended against an effort to extend the habeas remedy to detainees held in Afghanistan. Fourth, through the interrogation of those captured by the United States and our partners overseas, we continue to collect valuable intelligence about al-Qaeda, its plans, and its intentions. Fifth, this administration, like its predecessors, continues to successfully prosecute terrorists in our federal civilian courts. As a former federal prosecutor, I know firsthand the strength, security, and effectiveness of our federal court system. And here I know Cully agrees with me on this point. Given the reforms since 9/11, the federal court system is even more effective. And as a result of lengthy and mandatory minimum prison sentences authorized by Congress and the federal sentencing guidelines, those convicted of terrorism-related offenses often face decades, if not life, in prison. The results speak for themselves. Since 9/11, numerous individuals have been convicted of terrorism-related offenses. In the last 2 years alone, we have seen in our federal courts a guilty plea from the man who admitted plotting to bomb the New York subway system, a guilty plea from the man who tried to bomb the commercial aircraft over Detroit on Christmas Day 2009, a life sentence imposed on the individual who attempted to detonate a bomb in Times Square, and a life sentence imposed for participation in the 1998 bombing of our embassies in Kenya and Tanzania. Going back decades, the Department of Justice has successfully prosecuted hundreds of terrorism-related cases. Despite our successes, we know that the fight is not over. We know there is still great danger. Though degraded and on the run, we know that in the post-Bin Laden period, al-Qaeda and its affiliates still remain determined to conduct terrorist attacks against the United States. We know also that while al-Qaeda's core is degraded, it is a far more decentralized organization than it was 10 years ago and relies on affiliates to carry out its terrorist aims. We know that al-Qaeda is likely to continue to metastasize and to try to recruit affiliates to its cause. These terrorist threats are increasingly complex, multifaceted, and defy easy labeling and categorization. Just within the last several months, we have seen terrorists who, in my judgment, claim affiliation to more than one terrorist organization, belong to one terrorist organization and serve as a conduit to another, fit within our military detention authority but not our military commission's jurisdiction, fit within our military commission's jurisdiction but not within the military detention authority stemming from the 2001 authorization to use military force, and fit within neither our military detention authority nor our commission's jurisdiction, but can be prosecuted in our federal civilian courts. On top of all this are al-Qaeda's concerted efforts to recruit via the internet with a reach into the United States. Over and over again, we see individuals within the United States who self-radicalize and who find vindication for their hatred toward America in al-Qaeda's ideology and propaganda. In dealing with this category of people who are here in the United States, who have never trained at an al-Qaeda camp in Afghanistan or never sworn bayat to an al-Qaeda leader, we must guard against any impulse to label that person part of the congressionally declared enemy to be dealt with by military force. There is no jurisdiction to try U.S. citizens in military commissions, and our prior efforts in this conflict to put into military detention those arrested on U.S. soil led to protracted litigation in which the government narrowly prevailed in the federal appellate courts. As I said before, the military cannot always be the first and only answer. This is contrary to our heritage and in the long run will undermine our overall counterterrorism efforts. In responding to threats and acts of terrorism, we must build a legally sustainable arsenal and have all the legally available tools in the arsenal, whether it is lethal force against a valid military objective, military detention, interrogation, supporting the counterterrorism efforts of other nations, or prosecution in federal court or by military commission. Against this backdrop, we confront a series of laws and pending legislation concerning detainees that limit the executive branch's and the military's counterterrorism options, complicate our efforts to achieve continued success, and will make military detention more controversial, not less. Here are some specific examples. Section 1032 of the 2011 Defense Authorization Act prohibits the use of Defense Department funds to transfer any Guantanamo detainee to the United States for any conceivable purpose, no waivers or exceptions, including federal prosecution or to be a cooperating witness in a federal prosecution. Given the lengthy prison sentences mandated by Title 18 and the federal sentencing guidelines, and the range of offenses available for prosecution under Title 18, there are some instances in which it is simply preferable and more effective to prosecute an individual in our federal civilian courts. Section 1033 of the same law requires that before the government can transfer a Guantanamo detainee to a foreign country, my client, the Secretary of Defense, must personally certify to the Congress certain things about the detainee and the transferee country, unless there is a court order directing the detainee's release. After living with this requirement now for almost a year, I will tell you that it is onerous and near impossible to satisfy. Not one Guantanamo detainee has been certified for transfer since this legal restriction has been imposed. Rigid certification requirements reduce our ability to pursue the best options for national security in an evolving world situation and intrude upon the executive branch's traditional ability to conduct foreign policy. In this case, to determine when sending a detainee to another country for prosecution or reintegration would better serve our national security and foreign policy interest. Our nation is not the only one on earth that can deal effectively with this issue. The other potential consequence of such a rigid certification requirement is that it incentivizes the executive branch to leave to the courts the hard work of determining who can and should remain at Guantanamo. We want the courts less involved in this business, not more. Certain legislative proposals for the 2012 Defense Authorization Act are equally problematic. Section 1039 of the House version of the bill prohibits the use of Defense Department funds to transfer to the United States any non-U.S. citizen the military captures anywhere in the world as part of the conflict against al-Qaeda and its affiliates. No waivers, no exceptions. Within the national security community of the executive branch, we have determined that such an unqualified, across-the-board ban is not in the best interest of national security. Suppose the military captures a dangerous terrorist and doubts arise about our detention authority overseas. Suppose the military captures an individual who, it turns out, would be vital as a cooperating witness in a terrorism prosecution in the United States. Must the option to bring these individuals to a civilian courtroom in the United States be prohibited by law? Likewise, Section 1046 of the House bill imposes an across-the-board requirement that if military commissions jurisdiction exists to prosecute an individual, we must use commissions, not the federal courts, for prosecution of a broad range of terrorist acts. Decisions about the most appropriate form in which to prosecute a terrorist should be left case by case to prosecutors and national security professionals. The considerations that go into those decisions include the offenses available in both systems for prosecuting a particular course of conduct, the weight and nature of the evidence, and the likely prison sentence that would result if there is a conviction. A flat legislative ban on the use of one system, whether it is a commission system or the civilian courts, in favor of the other is not the answer. Section 1036 of the House bill rewrites the periodic review process the President's national security team carefully crafted for Guantanamo detainees designated for continued law of war detention. The proposed congressional rewrite mandates the use of military review panels, contrary to our best judgment. Our experience shows that interagency review is valuable and preferred to take advantage of the expertise and perspectives across the national security community in our government. Finally, Section 1032 of the Senate version of the 2012 Defense Authorization Bill includes what has come to be known as the mandatory military custody provision. Basically, it requires that certain members of al-Qaeda or its affiliates, quote, be held in military custody pending disposition under the law of war, end quote, unless the Secretary of Defense, in writing, agrees to give him up. For starters, the trigger for this requirement is unclear. Some of my friends on the Hill say that the provision is intended to apply only to those who have been captured in the course of hostilities, quote unquote. Read literally, the provision extends to individuals wherever they are taken into custody or brought under the control of the United States, who fit within our definition of an enemy combatant in the conflict against al-Qaeda and its affiliates, including those arrested in the U.S. by first responders and law enforcement. This would include an individual who, in the midst of an interrogation by an FBI or TSA officer at an airport, admits he is part of al-Qaeda. Must the agent stop a very revealing and productive interrogation and go call the Army to take him away? On top of all that, the provision adds that the individual must be a member or part of al-Qaeda or an affiliated entity. While we use the phrase al-Qaeda and its affiliates publicly to describe the contours of the conflict in non-legal terms, the term affiliated entity has no accepted legal meaning and has never been tested in court. Likewise, the phrase in the bill, a participant, quote, a participant in the course of planning or carrying out an attack against the United States, end quote, has never been tested in court. For this and future administrations, we will oppose efforts to make military detention more controversial and restrict the executive branch's flexibility to pursue our counterterrorism mission. The executive branch, regardless of the administration in power, needs the flexibility, case by case, to make well-informed decisions about the best way to capture, detain, and bring to justice suspected terrorists. The conflict against al-Qaeda is complex and multifaceted. Congress must be careful not to micromanage, complicate, and impose across-the-board limits on our options. Both the Congress and the executive branch must be careful not to impose rules that make military detention more controversial, not less. I have spoken today about ways to legally solidify and improve armed conflict, not end it. This should not be the natural order of things. But war is sometimes necessary to secure peace. You heard me describe the tragic but heroic story of a young naval officer who lost his eyesight to an IED. Martin Luther King, the man for whom we dedicated a memorial on Sunday, said that in the end, an eye for an eye leaves everybody blind. No matter how much longer this conflict will go on, we should all continue to believe that the arc of the human experience on Earth is long, but it bends toward peace. Thank you all very much for being here. Thank you for listening.
Thank you, Jay, for that thorough and understandable and common sense speech. I'm going to ask, take the prerogative as the host to ask the first question. I know many of you have questions. But my question stems from a paper that we just published at Heritage that I authored called Common Sense Principles for Detainee Policy, which is available outside or available on the web at www.heritage.org. And we also believe that the mandatory military custody provision, as you and I have discussed, is very problematic in practice, and that the executive, whoever the executive is, should have all tools available to him or her in a fight against terrorist organizations and affiliate organizations like the ones at hand. One thing we cover in our paper that you didn't touch on, and I'll put this question to you, is there are proposals on the Hill regarding reaffirming, and perhaps some would say extending, the authorization for use of military force, which was passed on September 18th, 2001. And could you spend a little time with us giving us your thoughts on that topic, whether it makes sense, how it works or doesn't work in practice?
Sure. I have a couple of thoughts about that. There is, in the House authorization bill, a provision to essentially renew the AUMF from 2001 and makes express reference to, as I recall the bill, the Taliban, Al-Qaeda, and associated forces. The Senate version of the Defense Authorization Bill renews the AUMF in the respect of detention only, not to imply that it's not renewed in other respects or it's not viable in other respects. But the Senate bill makes an express reference to detention authority. I was asked about this in March by the House Armed Services Committee, and I testified then and continue to believe that the authorities we have now in the Department of Defense are adequate given our interpretation of those authorities to address the threats that I have had occasion to evaluate. And I think that's almost exactly what I said, word for word. Now, having said that, I do think that I think that the provisions, particularly the House provision, have become very controversial. There's a lot of debate about the House provision on the House floor when it came to the House floor as part of the authorization bill. And a lot of people in debate interpreted that language as an effort somehow to prolong the operations in Afghanistan. That, frankly, is not my. It's not an effort to make some sort of global war on terror indefinite. And in that respect, I think that the political debate has become somewhat overheated. My understanding of the intent of the draftsman of that provision was to more or less codify what they believe to be our existing interpretation of our authorities. Now, I think the reason that we in this administration have concerns about efforts to do that is because at the end of the political process, what I don't want to end up with is something less than what we thought we already had by way of legal authorities through the authorities on the books and our interpretation of our authorities that are on the books. And in the detention context, as I said earlier, the courts have largely accepted our interpretation. So at the end of this process, at the end of this legislative season, and I've been very plain about this with those involved in this, that we don't want to end up with less than what we thought we already had. So I'm sure that this will work its way through once the authorization bill gets to the Senate floor, once they get to conference. But those are my thoughts.
All right, we have received a couple questions via Twitter, but I want to honor the people who are actually live here and then go to the tweeters. The gentleman in the back with the, I'm colorblind, is that a red tie? Yes, and the dark hair. Please, for all questions, please identify yourself, your organization, and then actually pose a question to the General Counsel.
My name is Roman Martinez. I'm an attorney at Latham & Watkins, and thank you, Mr. Johnson, for coming here. My question is actually about a slightly different topic, which is the administration's views and your thoughts on the targeting of U.S. citizens who are participating in the conflict against us using drones or other lethal means. I wonder if you could share your thoughts on that and explain your views and the administration's views on that subject.
Nice to see you again. And let me know when you're ready to leave private practice. But anyway,
I think that's a job offer.
Not quite. No, it's come work
Sort
for him.
of, yeah.
In general, and the courts have said this, the Supreme Court has said this, those who are part of the congressionally declared enemy do not have immunity if they are U.S. citizens. As I'm sure you know, in the Quirin case, 1942, I believe it was, and much more recently in Hamdi, 2004, the courts essentially endorsed detention, and in the case of Quirin, the prosecution and military commission of someone who was a U.S. citizen. There are special considerations, I believe, when it comes to U.S. citizens, and particular care that should be taken if we encounter somebody who has U.S. citizenship. I am satisfied that the military is conducting itself in full compliance with domestic legal authorities, law of armed conflict, and international law. So, and I believe, by the way, that I believe that at some point we'll probably have more to say on the topic.
Well, while you're standing, Jay, why don't you
I'm standing, yes. Okay.
let us in, since no one's watching, on this little tiff between you and alleged tiff in the newspaper between you and the State Department lawyer, Harold Coe, on this topic per se.
I think, frankly, that the so-called tiff between Harold and myself is largely exaggerated. Journalists like to find controversy, difference of opinion within the executive branch. Frankly, and I'm sure Harold would agree, it's really exaggerated. The particular context that you're referring to, I think Harold and I both agree that when it comes to Al-Qaeda, and the concept of associated forces, a group can become an associated force provided that there are two things. One, sufficient contacts, connections, affiliations with the core group, and two, an element of co-belligerency with the core group in the fight against the United States and its coalition partners. And Harold and I both agree on that proposition. So, frankly, I do think that the supposed disagreement is exaggerated. On the other hand, you know, if lawyers agree on everything within the executive branch, within the federal government, then maybe we're not thinking hard about these subjects and having a robust debate to get to the right answers. And I know from sitting around my conference table, I want disagreement and debate within the Office of General Counsel. And there are one or two lawyers who typically come down on one side and a couple more that typically come down on the other side. And they state their views and stake out their positions, and I ask for their legal support for their positions. And we get to what I believe is a healthy, sustainable conclusion. It's when you don't have those discussions and you lapse into groupthink that I think can lead to dangerous results.
Your answer reminds me of a question from a reporter who shall be nameless, who's here in the audience today. On September 6, 2006, when we rolled out the DoD directive on detainees, and it included in Enclosure 3, Common Article 3, the Geneva Conventions, and this reporter, male or female, said, I understand there was actually a debate in the administration about whether to include this. And my response was, yeah, there was a robust debate, and at the end of the day, that was better for the system than not. All right, in the front, Ben.
Thanks. Benjamin Wittes from the Brookings Institution.
Hello, Ben.
How are you? You take sharp issue, and I certainly agree with your criticisms of various extant legislative provisions. But you've also described the objective of the administration as a stable, legally sustainable legal framework. And presumably the role of Congress in the development of that framework is not zero. So my question is, if Congress wanted to be constructive in helping to build that framework, what is the positive agenda that it should be thinking about rather than these list of restrictions on things that you guys think you should have flexibility on?
Well, first of all, Congress has an oversight role, and I believe in that oversight role. So I am on a regular basis meeting with the counsel for the House and Senate Armed Services Committee, talking to them about what we're doing, my latest interpretation of our legal authorities and so forth, because I want them to know how we are applying the authorities that they have given us. And I believe strongly in Congress's oversight role. I hope that the Congress would consider working with us to help us build that sustainable framework. And a perfect example of that was the Military Commissions Act of 2009. We had the 06 Act, we had the Supreme Court decision that followed. There was a fair amount of controversy and debate in the run-up to the 06 law. And when I came into office, we started thinking about ways to reform the system. And right at about the same time, my colleagues on the Hill in the House and Senate Armed Services Committee were thinking along the same lines. And we worked together on a bipartisan basis. There is still some bipartisanship that occurs on the Hill, I find. And there's a fair amount of it around the Armed Services Committees. And so I generally work with Democrats and Republicans in both committees. And that was an effort to help sustain and solidify our legal authority for reformed military commissions in a way that we all believed was more sustainable, more credible, took out some of the more controversial aspects of the 06 law. So to me, that is a good example. I think, as I said in my prepared remarks, that we have to be careful that Congress not try to micromanage, not legislate certain options, be taken off the table completely, because the future can be uncertain, and things can go in unanticipated directions. So I hope I've answered your question, Ben.
You did a good job sort of answering the question. Perhaps others will press you. Let me go first to Kate and then to Julian, if you still have your question, Julian.
Kate Martin, Center for National Security Studies. Thank you, Mr. Johnson. And actually, as a follow-up somewhat to that question, it seems to me that the administration has been very clear that your authority to use military force, both in the targeting context and the authority to detain people militarily, is tied to the authorization of the use for military force, a position which we appreciate. And I also understand that it's the administration's position that you have the authority you need to go after new associated groups, at least like Al-Qaeda in the Arabian Peninsula. So, and I would assume that the legal analysis says that with the deployment of U.S. military force comes targeting authority and law of war detention authority. So my question is, not as a matter of legal requirement, but as a kind of matter of constitutional good practice, does it make sense 10 years later to go back to Congress and say, yes, you had in mind invading Afghanistan, since then the war has bled over to Pakistan, now we need to exercise, use our military assets against AQAP, which was not in existence at the time, and we want specific congressional authorization to use military force there. And with that will go law of war detention authority, targeting authority, et cetera. And that should there be another such group, that the administration again return to Congress and tell Congress the contours of the authority that it needs, rather than leaving it up to Congress to say, you can have it for the whole world whenever you want.
Okay, a couple of things. One, what I said was that I thought that our authorities were adequate to address the threats that I've had occasion to evaluate. That's one. And without getting into specific groups, the concern that we have is that the congressional legislative process is a sausage-making process. We have two competing versions of that effort in the House and Senate right now that look very, very different from one another. And so I become very nervous when Congress decides to undertake to rewrite the authorities that I believe I have now. And I do not know how it's going to look at the end of this process. You know, if in the abstract I could be king of the legislative branch and I could write my own laws, but I can't, this is not a monarchy, then I would take more comfort in the principle that you've articulated. But you know, in the pending legislation now along these lines, there are new concepts built in, like, you know, captured in the course of hostilities, for example, in the Senate bill, which is a phrase that is not tested in court. And so that is our concern.
Julian Barnes.
Julian Barnes, Wall Street Journal, and I may have been the reporter Cully was talking about there. My question is this, and it sort of follows along some of the queries we've had today, which is you've talked about the categorization problems you've had in recent days, that certain individuals might be covered by military commissions, but they might not have the other law of war authorities. So that makes me think maybe there's a role for Congress in clarifying that. But then you've also been critical of the use affiliated entity in the legislation that's come before the Congress. So, one, how should Congress clarify what the clarify who you have jurisdiction over, and two, do you think, just for clarity, going forward, do you believe that Guantanamo could take another captured detainee, or is that off the table now?
Let me answer the last question first. It is the firm policy of this administration not to add to the Guantanamo population. The President pledged to close Guantanamo, and we continue to be committed to that goal. And so we do not intend to add to the Guantanamo population. The military commission's jurisdiction is different from detention authority. Our detention authority for Guantanese is the March 13th, 2009 definition that I and others in this room helped to write. And that is somewhat different from commission's jurisdiction and very different from the jurisdiction to prosecute someone under Title 18, United States Code and civilian courts. And so my remarks should not be interpreted as an invitation to expand military commission's jurisdiction or to in some way expand our detention authority. As I said before, I think that we have to be careful about expanding the role of the U.S. military in our society. I do believe that if an individual doesn't fit within our detention authority or commission's jurisdiction, then we have to look seriously at whether that person, and we should, and we have, looked seriously at whether that person can be prosecuted in a federal criminal court, which has a number of different ways to prosecute that individual for material support for terrorism, other acts that result in very, very, very lengthy prison sentences. I used to think that when I was a prosecutor, narcotics prison sentences were long, but they pale in comparison to what the federal sentencing guidelines and the federal law calls for when it comes to acts of terrorism. So that's it.
This will be a quick question. We have time for one more. This was a tweet from Carol Rosenberg at the Miami Herald. Quote, "Is the Pentagon looking at Charleston Navy brig for Camp Justice proceedings?"
Like I said, we remain committed to closing Guantanamo. We have from time to time looked at alternate locations, so that has involved, over the last 2.5 years, looking here and there, so I think that's probably about all I want to say.
Okay. And it wouldn't surprise some in this room if the previous administration looked at alternative locations. There was a question from this lady here. Please identify yourself and ask your question.
Kate Brandon, Defense News. I was wondering if you could comment on what the impact or lack of impact there would be if Congress is unable to pass an authorization bill for 2012, and are there any areas that are particularly complicated by that?
Yes, that is a complication for us. There are authorities that, in fact, I'm looking at right now that expired at the end of this fiscal year, authorizations, not appropriations, that expire at the end of this fiscal year that are extremely valuable to us in what we're doing overseas. Unless the Congress acts to pass a new authorization bill or expressly deals with something in a new appropriations bill or a CR, we have real problems. And so, it is the case that every time the Congress, instead of passing a full year's appropriations bill, passes a CR, there are some authorities that get left behind that we have to scramble to figure out how to cope with. So all of us hope that what we've seen over the last year or two does not become the norm.
Well, folks, I think we've had an excellent discussion and repartee today. Typically, we give our speakers a heritage tie. I'm afraid if I gave Jay a heritage tie, he might not be allowed in the White House, and I want him to stay in his job. And so because General Meese is not here, but because he's written, along with others, the Heritage Guide to the Constitution, which is an excellent expose on the Constitution and the various provisions thereunder, and I know Jay is a student of the Constitution. On behalf of the Heritage Foundation and General Meese, we provide you this and ask you to come back again, and let's all give Jay a warm round of applause. We're adjourned.
Wall Street Journal.
Yes. We're at,
Do you live in New York?
we're at Boston. We're at 14 and 4.
Just work here? The fair here? Work here?
Oh, okay. We're actually moving over and down a couple blocks further into.
I've worked for a lot of departments, but I can't do that all the time. Quite a different thing.
That's great.
Oh, hi. It's Sunday. Oh, sorry.
Senate Majority Leader Harry Reid may now allow the Senate to take up the defense programs bill. Earlier, Senator Reid said he would not bring up the measure unless certain provisions relating to accused terrorists in detention were removed.